I'll continue with the statutory tribunal. Now, as I have discussed about Article 2323A, which speaks about the tribunals to be established for the services, public services. Now, we'll be discussing on Article 323B, which empowers the appropriate legislature, central or state, depending upon the legislative competence, to set up tribunals which are specially for dealing with matters such as tax, foreign exchange, import and export, industrial and labor disputes, land reform, sealing on urban property, elections to parliament or state legislature, production, procurement, supply and distribution of foodstuffs and such other goods as may be declared by the President to be essential goods. So you see, Article 323B specifically tells that there should be tribunals which deal with matters for tax, foreign exchange, labor disputes, industrial disputes. So you have, while studying the labor law, you have already studied about the Factories Act, Industrial Disputes Act, Minimum Wages Act. In the labor law also you will get so many tribunals which is established under that particular act. So it is as per the constitution which is provided under Article 323B. These tribunals under Article 323B, it can be authorized to try certain categories of criminal offences, and it does impose penal sections. This is an innovation in the Indian legal system, for till now criminal punishment were imposed only by the courts and not by the judicial bodies. But the tribunals also impose penal sections. Now, the law made under 323A and B is intended. It specify procedures to be followed by the concomitant tribunals and may also exclude the jurisdiction of all the courts except the Supreme Court's jurisdiction under Article 136 of the Constitution. See, here we can mention about the case that is of SP Sampat Kumar versus Union of India, where the Supreme Court held that a tribunal could be a substitute for the High Court. However, in L. Chandra Kumar versus Union of India, Justice Ahmadi, speaking for the unanimous court, held that administrative tribunals under Article 323A could examine the constitutional validity of various statutes or rules. There will be one exception to this rule. The administrative tribunals would not be competent to examine the validity of the statute under which they are created. In such cases, the appropriate High Court would have to be approached directly. Barring cases where the constitutionality of the parent act is challenged, all questions regarding services must be raised only before an administrative tribunal, and only writ appeals could go to a division bench of a High Court. From a decision of the High Court's division bench, an appeal could be preferred under Article 136 of the Constitution of the Supreme Court. Now see, in exercise of the power conferred by Article 323A of the Constitution, Parliament has enacted the particular act, that is Administrative Tribunals Act 1985. It is an act which provides for the adjudication by administrative tribunals of compliance with respect to recruitment, condition of services of persons appointed to public services of a union or states or any other local authority in pursuance of Article 323A and for the matters connected therewith. The act shall not apply to any members of the naval, military or air forces or any other armed forces of the Union. And it is also not applicable to any officer or servant of the Supreme Court or any of the High Court or court subordinate thereto, secretarial staff of either houses of the Parliament or state legislation. Now see, the Administrative Tribunals Act, which is formed as per the constitutional provisions, it has provides for three types of tribunals. Number one is that the central government establishes an administrative tribunal called the CAT, that is Central Administrative Tribunal, which has its jurisdiction to deal with the service matters pertaining to the central government employees or of any union territory or local or other government under the control of the Government of India or of a corporation owned or controlled by the central government. Next is the central government may, on receipt of a request in his behalf from any state government, establish an administrative tribunal for such state employees. So this is the second category of tribunal. And the third is the joint administrative tribunal, which means two or more states might ask for a joint tribunal which exercises powers of the administrative tribunals for such states. So that is your three types of tribunals as per Administrative Tribunals Act. That is your Central Administrative Tribunal, you can say State Administrative Tribunal, and the Joint Administrative Tribunal. Now, Article 323A is also, as I have told you, it is confined to matters relating to the public services. And Article 323B relates to tribunals for the matters of taxation, foreign services, labor disputes, land reforms, elections, essential goods, etc. Under Article 323A, only one such tribunal may be created for the Union and one for each state or two or more states together. So far as 323B is concerned, the appropriate legislature is empowered to establish a hierarchy of tribunals relating to each subject specified in Clause 2. Moreover, under Article 323A, the power to make such law belongs exclusively to Parliament. And under Article 323B, it is divided between the Union and the state legislature according to their respective legislative competence. But both these articles, 323A and B, it cannot be interpreted to mean that they prohibit the legislature from establishing tribunals not covered by these articles so long as there is legislative competence under an appropriate entry in the 7th schedule. These two articles do not take away that legislative competence. Moreover, it is pertinent to note that the word adjudication, which is used in both the articles 323A and B, indicate that the jurisdiction of tribunals set up under both the articles should be confined to the adjudication of quasi-judicial bodies relating to administrative matters, such as disputes relating to services, matters specified in Article 323B, that is your taxations, labor, imports, then determination of an election dispute, assessment of a tax, adjudication of industrial disputes, termination of services, order of a revenue officer like a custom authority imposing penalty, order affecting an individual's property. Now you see why these tribunals are established, for there are very vital reasons. First and foremost, the traditional justice system, it provides inadequate to decide and settle all the disputes requiring resolution. It was slow, costly, inexpert, complex, and formalistic. It was already overburdened, and it was not possible to expect speedy disposal of even very important matters, that is, disputes between employers and employees, lockouts, strikes, etc. These burning problems cannot be solved merely by literally interpreting the provision of any statute, but it requires the consideration of various other factors, and this cannot be accomplished by the courts of law. Therefore, these industrial tribunals and labor courts were established, which possess the technique and expertise to handle these complex problems. The second very reason is that administrative authorities can avoid technicalities. They take a functional rather than a theoretical and legalistic approach. The traditional judiciary is conservative, rigid, and technical. It is not possible for the court of law to decide the cases without formality and technicality. On the other hand, administrative tribunals are not bound by the rules of evidences and procedure, and they can take a practical view of the matter to decide the complex problems. Thirdly, you see, administrative authorities can take preventive measures. For example, licensing, rate fixing, etc. Unlike regular courts of law, they have not to wait for parties to come before them with disputes. In many cases, these preventive actions may prove to be more effective and useful than punishing a person after he has committed a breach of any legal provision. Then administrative authorities can take effective steps for enforcement of the aforesaid preventive measures, example suspension, revocation or cancellation of licenses, destruction of contaminated articles, etc., which are not generally available through the ordinary courts of law. Then in ordinary courts of law, the decisions are given after hearing the parties and on the basis of evidence on record. This procedure is not appropriate in deciding matters by the administrative authorities, where wide discretion is conferred on them, and the decisions may be given on the basis of the departmental policy and other relevant factors. Sometimes the disputed questions are technical in nature, and the traditional judiciary cannot be expected to appreciate and decide them. On the other hand, administrative authorities are usually meant by experts who can deal with and solve these problems. For example, problems relating to atomic energy, gas, electricity, etc. In short, you can say that administrative tribunals do their work more rapidly, more cheaply, more effectively than ordinary courts. It possesses greater technical knowledge and fewer prejudices against the government. It gives great heed to social interest involved, decide disputes with conscious effort at furthering social policy embodied in the legislation. Now see the characteristics of administrative tribunals. As we have discussed the why we need administrative tribunal, there are some characteristics of administrative tribunals. An administrative tribunal is the creation of a statute, and it has a statutory origin. Secondly, it has some of the trappings of a court, but not all. Thirdly, an administrative tribunal is entrusted with the judicial powers of the state, and thus it performs judicial, quasi-judicial functions as distinguished from pure administrative or executive function, and is bound to act judicially. Even with regard to procedural matters, an administrative tribunal possesses power of a court. For example, to summon witnesses, to administer oath, to compel production of documents, etc. An administrative tribunal is not bound by strict rules of evidence and procedure. Sixthly, the decision of most of the tribunals are in fact judicial rather than administrative, inasmuch they have to record findings of the fact effectively, objectively, and then to apply the law to them without regard to executive policy. Most of the administrative tribunals are not concerned exclusively with the cases in which the government is the party, and they also decide disputes between two private parties. For example, election tribunal, rent tribunal, industrial tribunal. On the other hand, the income tax tribunal always decides disputes between the government and the SS. Eighthly, administrative tribunals are independent and they are not subject to any administrative interference in the discharge of the judicial or quasi-judicial functions. Ninthly, the prerogative writs of certiorari and prohibition are available against the decisions of administrative tribunals. You see, thus taking into account the functions being performed and the powers being exercised by the administrative tribunals, it can be said that they are neither exclusively judicial nor exclusively administrative bodies, but are partly administrative and partly judicial authorities. After discussing why we need the tribunals and what is the characteristics of a tribunal, let us discuss what is the distinction between a court and an administrative tribunal. Firstly, a court of law is a part of traditional judicial system where judicial powers are derived from the state and the body deals with king's justice. It is called a court. On the other hand, an administrative tribunal is an agency. It is created by a statute and invested with judicial powers. Secondly, whereas ordinary civil courts have judicial power to try all suits of a civil nature, excepting those whose cognizance is either expressly or impliedly barred, tribunals have power to try cases in special matters that statutorily confound. Thirdly, the mere lack of general jurisdiction to try all the cases of civil nature does not necessarily lead to an interference that the forum is tribunal and not a court. A court can also be constituted with limited jurisdiction. Fourthly, judges of ordinary courts of law are independent of the executive in respect of the tenure, terms, and conditions of services. That is independence of judiciary, as you know. On the other hand, the members of the administrative tribunals are entirely in the hands of the government in respect of those matters. Fifthly, the court of law is generally presided over by an officer trained in law. But the president or a member of a tribunal may not be trained as well in law. Next, in a court of law, a judge must be an impartial arbiter, and he cannot decide a matter in which he is interested. On the other hand, an administrative tribunal may be party to the dispute to be decided by it. Next, the court of law is bound by all the rules of evidence and procedure, but an administrative tribunal is not bound by those rules unless the relevant statute imposes such an obligation. The next difference is that a court must decide all the questions objectively on the basis of the evidence and materials produced before it. But an administrative tribunal may decide the questions taking into account the departmental policy or expediency, and in that sense the decision may be subjective rather than objective. Next difference is that while a court of law is bound by precedents, principles of res judicata and estoppel, an administrative tribunal is not strictly bound by them. Lastly, a court of law can decide the wires of legislation while an administrative tribunal cannot do so. So this was a brief discussion on the statutory tribunal.